Greetings, everyone. I am Michael Ryan. I am Vice President and Librarian of the New York Historical Society, and I'm delighted to welcome you to this installment of our ongoing series of conversations with Library Fellows. Library Fellows, as many of you will know, are scholars who have won awards given by the Historical Society that allow them to be in residence at the Society for an academic year to pursue their own research projects using the richness of our collections. This evening, though, I have asked not one of our current fellows to join us, but actually a fellow from last year. Her name is Julia Rose Kraut, and some of you probably will remember her. She's an enormously accomplished JD PhD who is able to navigate skillfully the two professions of the law and of history. The reason I wanted to invite Julia to this program this evening is because she has a new book out from Harvard University Press entitled Threat of Dissent. It is a deeply researched, extremely well-written look at the legal and political history of ideological exclusion and deportation in the United States. And I am sure you will join me in concurring that it is nothing if not timely. Our country, the US, has a long tradition of ideological persecution and exclusion, going all the way back to the very beginnings of our country, to the administration of John Adams and his Federalist colleagues, who managed to write the first Alien Friends Act of 1798, which created the legal foundations for ideological exclusion. As we all know, when times get tough in this country, whether it's war or threat of war, pandemic, riots, social unrest, economic deprivation, scapegoating begins. And Julia's book is populated by the likes of people who have been scapegoated by the government over a long period of time, including people like Emma Goldman, Charlie Chaplin, John Lennon, Clarence Darrow, and a host of others. It's an eerie coincidence that Julia's book appears at the very same time as Larry Nye's Demagogue is out. Demagogue is a long and revealing look at the life and career of Senator Joseph McCarthy, certainly one of the villains of Julia's account. Julia will be joined this evening by Professor Robert Tsai of the American University College of Law in Washington, DC. We're delighted to have Professor Tsai with us and honored that he's chosen to join us, since he's had a distinguished career both as an advocate and as a scholar, someone committed both to the First Amendment and to civil rights more broadly. His published work embraces a large swath of the law and history, from democratic theory and American political culture to presidential leadership and criminal procedure. His latest book is Practical Equality, Forging Justice in a Divided Nation, which came out last year. Deeply rooted in historical experience, the book is a pragmatic look at actually trying to realize equality in challenging times. Before we begin, I want to remind all of you to please use the Q&A box on your menu at the bottom of the page to send your questions. The conversation will go on for about 30 minutes or so, after which we'll turn to your questions, which you should submit using the Q&A feature at the bottom of your screen. So now it is my pleasure to turn it over to Robert and Julia. Please begin.
Thank you, Michael, and thank you to the New York Historical Society for having us. It's one of my very favorite places in New York City to visit, and I can't wait to be able to do it again. When I heard that there was an opportunity to chat with Julia about her new book, I leapt at the opportunity because I knew that her work was so incredibly timely. We're living through a period in which so many prominent people are asking us to think of people in groups as a threat, outsiders as the basis of disease and violence, and also in terms of dangerous ideas. And Julia's wonderful book, which we're going to get into in a moment, really gives us an opportunity to kind of take the long view and understand sort of two threads here that are happening at the same time, right? One thread is our country's kind of long-term practice of, unfortunately, excluding and deporting people at times based on who people are, where they come from, what they look like, what their race is, what their religion is. The other thread, which her book focuses on, we haven't seen as much of in terms of putting these two ideas together, and that is excluding people or deporting people on the basis of what we think they believe, what they've said, or the associations that they've had, the kind of groups they belong to, the friends and compatriots that they share. So it's really my pleasure to be able to speak to Julia about her wonderful book. Julia, maybe the best place to begin is I understand that you actually were able to work on the book while you were a fellow at the Historical Society. Is that right?
Yes. And I want to thank Michael for inviting me to talk about the book, and also to thank everyone at the New York Historical Society and the staff for organizing the event. And I was able to do work on this book and do some research about 2 years ago. And I want to thank the librarians and the archivists without whom I would not have been able to write this book. The collections at the New York Historical Society are tremendous, and it was a wonderful experience.
So I've been meaning to ask you, how did you originally get the idea for the book? What sort of attracted you to this subject, and when do you sort of identify the beginnings of this book?
20 years ago, actually, when I was a college student up at Columbia University. So this has been kind of 2 decades in the making. As I was a college student, I began to write and research about law and history, and I was very lucky that I was studying with some brilliant professors, Eric Foner, the late Alan Brinkley, and both of them really encourages interdisciplinary work and my interest in law and history. And so while I was at Columbia, I was looking at the anarchist movement. And I was very interested in the suppression of anarchists in the late 19th and early 20th century. And I came across a case of an anarchist named John Turner, who was from England and was excluded from the United States in 1903. Now, he was excluded under the Alien Immigration Act, which was passed in the wake of the assassination of President McKinley in 1901 by an anarchist. And what I found that was fascinating about this is that John Turner challenges his exclusion under the act, which barred anarchists from entry to the United States, authorized their deportation, and barred their naturalization. And he was represented by Clarence Darrow, and they take the case to the Supreme Court. And unfortunately, Turner loses. And the Supreme Court says, those who are coming to the United States, foreign non-citizens, have no constitutional rights, including First Amendment rights. And you can't challenge your exclusion. So the Supreme Court upholds the law and Turner's exclusion. And what I found was fascinating, that it was an intersection of First Amendment and immigration law. And I never heard about this before. I had never seen this before. I'd not really heard about this case. And so what ends up happening is I'm fascinated by this intersection. And I go off to law school. And I go to American University Washington College of Law before you arrived, Robert. And I take this interest with me. And actually, my First Amendment professor was Jamie Raskin. who's now in Congress. But he also was interested in what I was doing and my interest in anarchism, but also in this intersection of First Amendment immigration law. And I began to delve deeper. And it was at the same time that it was the very first kind of few years of the War on Terror. And I was reading in the news about scholars who were being excluded under anti-terrorist provisions. And it made me think about 100 years before and this Turner case. And I said, there's got to be history here. And so I took my interest and I continued to do research, went off to graduate school, got a PhD, and I said, you know what, I got to write a book. I got to write a book about this, because as I began to do more research, I found a very rich history. And Michael mentioned kind of that encompasses Charlie Chaplin and Graham Greene and Emma Goldman and John Lennon and Carlos Fuentes and all these people. But what was fascinating was that this runs through ideological exclusion, deportation, runs through immigration history and First Amendment law and history. And we needed a book about it, and so I wrote it.
So I want to make sure that we touch on some of the famous cases, because I do think that's a fascinating part of your book. There's a number of important characters, people who, that many people have heard of, but also some figures I think that are you might consider them heroes, people who try to do some things about these deportations, sort of working within agencies, for example, to try to limit some of those things. And these are some people that most readers will not have heard of. And we want to make sure and touch on that as well. But before we do, I want to come back to the beginning of your interest in this subject. You mentioned the Turner case, the one involving, of course, a British anarchist. And I want to ask you, I mean, this is very interesting because, of course, the authorities had heard of Turner by the time they were thinking about what to do, and they actually let him into the country, right? They actually, as you write, they let him into the United States, and then what they do is they try to grab him and to deport him. And I guess I want to ask you, like, do you have a theory about why they let him in? Because in so many other instances you talk about, they don't do that. It's easiest to exclude somebody if they're not already here. You deny them a visa, you put them on a no-fly list, something like this. But once you let them in, both politically and I think legally, it can be more challenging. So do you have a theory about why they let Turner in the first place?
So this is the beauty of archival research. So then you start to get into learning more about the case. And then you discover that this is kind of a test case. And it wasn't necessarily a test case on the part of John Turner and Emma Goldman. Emma Goldman had invited him to come. They weren't necessarily looking to challenge the law, but you also had surveillance of this correspondence. And immigration officials are tracking what's kind of going on, and the fact that the Turner is going to be coming to the United States. This was actually not his first trip, and there was concern about him and his visit in the 1890s. So now he's invited back, and there's we're going to use this new law, and we're going to try to exclude him. But initially they get the wrong Turner. They stop the wrong Turner, and then there's a little bit of discussion of, wait a second, we're going to have to maybe regroup here and think about how we're going to catch Turner. And so they decide to let him in. Now, how Turner gets into the country is another question. That's also whether he came in through Canada or through a port. But it's easier in a way to let him come in, get the right John Turner when he starts speaking, and he's invited, and then and what happens is they go to his talk, and then they snatch him up. So kind of in terms of exclusion and deportation, it's sometimes interpreted as a deportation case, but it's really under this exclusion law that he's gonna be deported back to England. But that's tricky. Remember, this is also before really our official visa system. And we don't have the same kind of rights that attach. They bring him to Ellis Island, they detain him, and he's given a hearing, and the challenge really takes place on Ellis Island and then through the federal courts.
Now, you pointed out that at some point, of course, the legendary Clarence Darrow gets involved, and we hear so much about Darrow's unbelievable one-loss record. This is one of the L's that he takes, right? He loses, and he doesn't just lose. It wasn't in a unanimous opinion against him, right?
It was
against Turner.
That's it.
The law that is used, as you point out, is one that is. And I think you described it this way, as sort of the first permanent. We've got some precursors that expire in the past at a certain point in time, but that I think you described this law as sort of the first sort of permanent law that authorizes either exclusion and deportation, depending on the scenario, of people who espouse certain ideology, or can be said to be identified with certain groups that espouse a certain ideology. And here, you describe it as part of, I guess you call it the war on anarchy. I think is the name of your title. But you have a phrase that you use. Let me see if I can find it here. You say that anarchy was a foreign ideology imported by immigrants, spread like a contagious disease. I found that one sentence jumped out to me as perhaps the most perfect encapsulation of, at least the descriptive part of your book, which is that, if we ask ourselves, what is the foundation? What is the rationale for laws like this? It's what you just say, right? That there is a perception that there are dangerous ideas coming in from outside of the country, spread by migrants and travelers. And that we need to stop. We need to contain those ideas, and we need to stop kind of regular Americans from being polluted by those dangerous ideas. Here, anarchism is specifically identified. I wanted to ask you a little bit more of your broader thesis, though, at the moment, because there seems to be sort of two main themes in the book. One is what you describe as a kind of impetus, a kind of cultural impetus, maybe an American impetus, to routinely try to exclude people, unwanted people, people with dangerous ideas, people from dangerous places. And then there is this other theme, which is the development of the law and the development of the legal ideas that I read you to say is mostly sort of bad news, right? That mostly it's facilitating this terrible impulse. There's a few bright spots, and hopefully we can get to those. But most of the time, we have a bunch of ideas that are legal ideas and laws, and then judicial decisions that end up, in one way or another, kind of authorizing this general impetus. Is that a fair characterization of the sort of kind of the historical aspect of your book?
Yeah, I think that this is, what you touched on is exactly what I'm arguing, which is what I found is that these laws, these ideological exclusion deportation laws, are passed often, at a moment of national insecurity and in the name of national security. So this is, during on the brink of war, during war, social upheaval, Great Depression, in the wake of some kind of attack on a person or on the United States. And it really taps into this fear of subversion in the United States. That's what we're talking about, kind of contagion, this kind of subversion that's going to bring down the United States and democracy. And this conflation with foreigners, that foreigners are seen as a source of subversion, the importers of subversion, or those spreaders. So we have an external threat of those coming in and an internal threat within the United States. And that kind of sparks this exclusion deportation. And ideological exclusion deportation is used as a political repressive tool. And what it is to suppress dissent and challenges to the status quo, to capitalism, radicalism, reform, and expressions of criticism of United States and United States policy. And so what you find is that over time, and what is remarkable about this long narrative, this story, is the consistency of that argument of the source of subversion being foreigners, and the tool of ideological exclusion, deportation, and the continuity of some of these laws. But what you're finding too is that the problem, and that's one of the issues in terms of that the Turner case touches upon, is that ideological exclusion deportation is this intersection of First Amendment and immigration law. But the majority of the Supreme Court has interpreted this issue as an immigration issue, not as a First Amendment issue. Even though people argue this is censorship, this is a form of censorship, and it is directly targeting dissent, and is the purpose of it is to suppress speech, and uses guilt by association, and is targeting belief and expression. And that is the argument against it. But the judiciary has said, no, this is an immigration issue, and we're going to apply immigration legal doctrine. And as you know, Robert, that plenary power doctrine, which gives the power to regulate immigration to Congress and the executive to enforce it, and the judiciary to grant it very liberal discretion, deference to the Congress and the executive to implement and pass these restrictions. And so this judicial deference to Congress and the executive, and the use of discretion by the executive to exclude or deport, is part of the problem. And what it does is it insulates ideological exclusion deportation from First Amendment protections, from the standard strict scrutiny, and all these free speech protections that we've gained over the course of the 20th century, and provides a lower standard. And that has made ideological exclusion deportation an enduring tool of political repression that we're still dealing with today.
I think the way you've described it is terrific. And I think there'll be a lot of readers, a lot of Americans who might be shocked to learn that even though they're here in the United States, that some of us may have a different First Amendment rights than others.
Yeah.
We might be working in the same place, we might be inhabiting the same space, but if, as your book points out, you are a non-citizen, or you are a visitor, and I want to bring in Emma Goldman because she's already come up, and she adds, her story adds kind of a wrinkle to the picture, which is not just kind of the typical exclusion of someone who's not here yet, or the deportation of a clear foreigner. But in Emma Goldman's case, she is actually a citizen. And so they want to get rid of her, but they're having a hard time getting rid of her. So tell us what her situation adds to this picture, because I think it's a very an important wrinkle to this. And it's kind of an additional tool, right, that the authorities have to suppress dissent.
That's right. And so what you have is that these public officials use ideological exclusion and deportation as a tool, preying on the vulnerability of non-citizens. Those outside of the United States, who I talked about with the Turner case, have no constitutional rights and can't really challenge their exclusion, but also those within the United States. And they're terribly vulnerable. Those who are not citizens can be deported. But then also those who naturalize, who become citizens, can be denaturalized and then deported. And so part of this story is not just about ideological deportation, but also how the US government also focuses on denaturalization in order to deport. And we often don't think about that, but we really do need to, especially now. I mean, when we're thinking about current issues of exclusion and deportation, denaturalization or bars to naturalization should be part of that conversation. Now, Emma Goldman had obtained citizenship. She was an immigrant from the Russian Empire, from Lithuania. And she had come and she had obtained citizenship through her husband. So this was derivative citizenship through marriage, which is no longer the case, but at the time she could do it. And so what ends up happening is that the entire United States government is determined to figure out a way to suppress Emma Goldman, suppress her speeches or kick her out of the country. And the barrier is her citizenship. So what they do is they have to denaturalize her husband in order to break her citizenship and leave her vulnerable to deportation. And that's what they do by 1909. And so people might have heard that Emma Goldman, along with her comrade Alexander Berkman, are deported in 1919 after World War I on the Red or Soviet Ark. But she had to be denaturalized first.
So I want to ask you about that because so they go after her husband because I presumably they can't find a way to denaturalize her directly. Is that right? So they
That's
say,
right.
okay. So as you point in your book, they go after her husband by alleging that he has committed fraud during the naturalization process. And was it only misstating his age? That's what I saw in the book, or were there other?
Oh, there might have been also in terms of kind of his relationship and his own citizenship through his father. So I go through a little bit of that in chapter 2, and then I talk about her deportation in chapter 3. So one of the things that I told this kind of long story because what ends up happening is you follow certain people. So you follow Emma Goldman from chapter 2 to chapter 3, from her giving speeches and her denaturalization to her deportation. The same way I'm also following lawyers and law and other deportees or those who are excluded. So
I wonder if we could shift gears just a little bit because we've only got so much time, but there's so much great stuff in your book. A lot of the book is about the horrible repressive things that happen not only to anarchists who may not themselves be personally engaged in violence, but are being suppressed because of their ideas, their speeches, their pamphlets, and this sort of a thing. And then, of course, you take your thesis into the kind of the Cold War period, where anti-communism is the perceived ideological threat from outside. And am I right to think that in terms of sheer numbers, in terms of kind of the sheer ferocity with which the federal government is now able to exclude or deport people on the basis of ideas, that this is the period where it's the most active, that they're the most active and successful in getting people out of the country?
What you have is robust laws, and you have kind of all-encompassing. So we start with kind of that anarchist period, and then we keep adding more groups. And eventually we're adding communists to the mix by the time we get to the mid-20th century. And so we're using deportation, denaturalization, and exclusion all at the same time in the 1950s. And that's where you get Charlie Chaplin is denied re-entry, and we have Graham Greene who's excluded, atomic scientist. Then later on we have Carlos Fuentes who is having trouble getting into the United States. And then you also have this effort to deport as well. And so all of it is kind of coming together. What's remarkable is that the law passed in 1952, the McCarran-Walter Act, persists and is on the books through the 60s, through the 70s, and through the 80s, which I describe. And so you have the Nixon administration using it to exclude, and the Reagan administration using it to exclude. So we have to also really pay attention to the laws on the books and what we're doing about that. And so it's a really remarkable story that encompasses the Cold War, but takes it through to the 80s.
So I want us to make sure and touch on some of the heroes, maybe a few people who certain readers may have heard of, but certainly a number of people who I had not heard of, at least with respect to this issue. For example, you talk about an assistant secretary of labor named Louis Post. More dramatically, Francis Perkins, who becomes Secretary of Labor, and both of these figures, do what they can with the discretion that they have within this agency to either not authorize or to stop certain kinds of proceedings from happening. Tell us a little bit more about that, because this seems to be an important development here, but there are limits to what is going on as well within the agencies, right?
Right. So discretion is very interesting, and it's a little bit tricky. And one of the things I do in my introduction is I talk a little bit about how I'm talking about discretion and what you're going to see throughout the rest of the book. Discretion held by immigration officials, as well as the Secretary of Labor, Secretary of State, the Attorney General, to deport, to exclude, as well as to admit and to defer or prevent deportation. And so what you find is that there are some who want to deport as many as possible. And there are others who say, wait a second, let's not deport. Let's figure out a way to prevent or delay or defer. And so I have examples of Louis F. Post during the deportations delirium in 1920. People might remember the Palmer raids. And he decides that he's not going to just rubber stamp those arrests and order deportations. And so he prevents many deportations because of his interpretation of the law. And so does Frances Perkins in the 1930s. She actually works hard to admit those and refugees and try to get those coming into the country who are fleeing Nazi Germany. But she also is trying to prevent some deportations and uses her interpretation of the law, which I talk about with the Harry Bridges case. Now, there's an attorney that people should know about, and I hope that they'll read more about in the book, named Carol Weiss King.
I think, as Julia, by the courts kind of borrowing from the immigration idea to kind of, as a way of ignoring the very serious First Amendment questions. The reason why I asked, for example, about people who are already here in the United States is it seems to me that once you've come in, once they've let you in, that your speech rights are, for all practical purposes, the same. They should be the same. Or in my family, I'm naturalized. My spouse is naturalized. My kids were born here. Why should it be the case that I am more fearful of my speech rights because of the possibility of denaturalization because I belong to the wrong group, someday? That seems deeply problematic. So, but I think it does have to come from Congress first. We have to decide to pull back those laws. We have to, if you want to have this power, we got to build more safeguards into those laws, and then perhaps we can start to expect the courts to, to do the right thing.
I'm going to one whole topic that we haven't touched on, and perhaps it's not part of your book, Julia, but I couldn't help but thinking about it in terms of the centrality of debates over immigration in this country. And that is, in the 1920s, of course, there is a major restriction on immigration immigration law that's passed in 1923, I think, which coincides with the popularity of the eugenics movement on the one hand, the resurgence of the Ku Klux Klan on the other, and the sort of doubling down on Jim Crow, the ultimate result. And I'm wondering, at what point does your book, or does the narrative implicit in your book, deal with things like civil rights? Because clearly, African Americans are caught up in this in a rather different way. They're not going to be deported. They're just going to be degraded, demoted, marginalized, shut in, shut down. They're not going to be deported. They're going to be able to say things, but they're going to get punished, not by exile, but by death, by lynching. Do you deal with this at all?
Oh, well, I certainly deal with the 1924 Act, the National Origins Act that I think that you might be referring to. And I also talk about that one of the problems is that when we get more immigration reform in the 1960s, during the height of the civil rights movement, that ideological exclusion and deportation remain relatively unchanged, especially ideological exclusion. And that's really important because it survives the Hart-Celler Act, which gets rid of those national origins quotas. And it's still there ready to exclude. In fact, it was used to exclude W.E.B. Du Bois's widow, Shirley Graham Du Bois, under the Nixon administration. And what's interesting there too is that we have a unique challenge. And this is something that it actually is covered in chapter 6. But how does one challenge, after the Turner case, how does one challenge exclusion? And it's through those who invite, let's say, a foreign visitor to come speak. And so I talk about the Ernest Mandel case, who is Ernest Mandel, a Belgian Marxist, who is invited to come speak, just like Shirley Graham Du Bois is invited to come speak. And they are excluded. And it's groups within the United States that actually take up the charge. And with the Mandel case, claim that it's their First Amendment right to hear him. And that's how they're going to challenge exclusion. And we still use that today. But I think the danger here too is in terms of the fact that we still have exclusion and deportation and the use of affiliations and views and expressions against those who are most vulnerable. So if you are a non-citizen trying to come to the United States, or if you're within the United States, whoever you are vulnerable. And especially we're finding that as more scrutiny and suppression of those who are involved with Black Lives Matter and the protests now, and looking at social media, how is that going to be used against those who are most vulnerable as well as citizens of the United States? Right. How are your affiliations and your participation in the protests going to affect your immigration status, your ability to come in and leave, but also in terms of your activities and U.S. citizens? So these issues are very much integrated, and we need to be paying attention, whoever you are.
So we have a series of questions here that relate to your sort of foundational piece here on anarchism. And they all relate to pretty much the same issue, and that is, isn't it the case that the prosecution of anarchists at the turn of the 20th century was directly related to the immigration flood from Italy and Eastern Europe at the time? And this is, a direct correlation between anarchists caught up in the web on the one hand, and the demonization of Italians and East European Jews especially, who make up the bulk of the people now coming into Ellis Island, only recently opened in the late 19th century.
So they are related. The Alien Immigration Act of 1903 is really a response to the assassination of President McKinley. And ironically, this is by a American citizen born in Detroit. Leon Czolgosz was an anarchist born in the United States who assassinated President McKinley. And he would not have been excluded or deported under the Alien Immigration Act. So it was targeting and this kind of conflation of radicalism and immigrants. Well, a lot of that was focused on Eastern European and Italians. There were other immigrants groups that were of concern, Germans as well. And it really was focused kind of on ideology. Now we get into closer to World War I and then into the National Origins Act, and then we can see that is directly to restrict Southern and Eastern Europeans and the concern there.
So right up Central Park West, we're right next door to the American Museum of Natural History. Out in front, there is, of course, the a statue of Teddy Roosevelt, which has received quite a bit of attention recently. But I have a question here that's kind of related to what we've been talking about. And that is, did Teddy Roosevelt have a strong position on the Turner case or on expulsion of radicals and immigrants in general?
Yes. So he advocated for tougher measures against anarchists. He became president because of the assassination of President McKinley, and was a strong advocate for restriction. And later on was also focused on immigration restriction as well.
Yeah, and of course, it's worth noting that Teddy Roosevelt also was a eugenicist, as were many people in the American Museum of Natural History at that time. That's a fact that seems to escape public attention. We're running out of time, and I have to ask one final sort of big question. You've touched on this, and Robert has too. Are we unique as a country in our position on deportation and expulsion, on clamping down on free speech, demonizing people with bad ideas, demonizing groups that we find strange, that we're afraid of? Is that part of American exceptionalism? Or is this something that goes on in many countries? I mean, I can't imagine this does not happen regularly in the UK over a long period of time. But again, I don't know the law there.
We are not exceptional. Now, I wrote a book and I was very kind of explicit saying what I'm looking at is the intersection of American immigration law and a First Amendment law. And so this is really an examination of what we do in the United States. And that's significant because everyone has their own different laws and how they treat speech. And I'm tracking First Amendment law and history and its jurisprudence and the different standards. And so that's very much part of the book. But lots of countries exclude or deport. Lots of those who were excluded from the United States were also excluded by other countries at the same time. And of course, if we're looking at the anarchist example, the anti-anarchism movement and concern about anarchists and assassinations in Europe was taking storm in the 1890s before the assassination of President McKinley. And so the war on anarchy in Europe had already gotten started, and the United States was a real latecomer. And so they were already very concerned and working with each other to bar anarchists and to deport and expel them and suppress them. And so what we see is that that impulse to exclude or deport continues. In fact, Ernest Mandel, who I mentioned before in who I focus on in chapter 6, was also barred from other countries, including France, because of some of his activities.
Thank you very much, Julia. Thank you, Robert. It's been great having you both. I'm sorry we're out of time, but I do want to encourage our audience to please go out and buy a copy of Julia's book, Harvard University Press, The Threat of Dissent. It will be well worth your time. It is nothing if not important at this moment in time in our history as we face challenges of this kind, right and left.
Also here, and buy Robert's book too. Thank you so much for this conversation, Robert. I really appreciate it.
It was my pleasure. It was wonderful to chat with you about the book.
Thank you both, and good evening to you all. Thank you for being with us. Good night.